Okay, well, we're going to call the meeting to order. It is 3:08. So first we'll do a roll call. Vanessa Kandow. Here. William Kernick.
Here.
Dawn Krushniak. Here. Mark Zelke.
Here, and I'd like to apologize for missing the last meeting. I have no good excuse. Just a bunch of flimsy reasons, so please forgive me.
Very good. And Shelley Spada here. Also present we have Terry Greeno from our County Board Liaison. Yes. And Scott Hartman.
Norm Bitten.
Norm Bitten. And do you want to introduce yourself?
Yeah, I'm the HR director. Again, I don't make these meetings very often because it's your convenience, and a lot of times it's a conflict. So I'm glad I could be here today, but I do have to leave at 4. So, hi.
Okay.
And for Kathy Bowles, performing important duties of capturing of what I always say. And this is Dan with our IT. He runs, because our meetings, we have different broadcasting. This one isn't being live streamed, is it? Wow, okay. There's a camera up there, just so everyone's aware. So our meetings are live streamed, which is good for transparency. So what you say is going to be on the record. Keep that in mind. But I want to, thank Cheryl for being here. Because what she does as HR director, this is a very difficult time slot. But the reason why she's here, and you see her on the emails, is because in our ethics ordinance, we have an ethics advisor that's named, and that's the HR director. So her role is if an employee sees, has an issue or wants to know if they can, do something, whether it's going to run afoul of the ethics ordinance or maybe a potential violation, she's really the employee's resource. They will go to her, they'll confer with her and say, this vendor offered me, a frozen turkey for Thanksgiving. Can I take it? That's really where the employees would go. So it's important that she's involved with these meetings and with the ethics ordinance. She and I confer quite a bit, and over the years we have. But that's her role, and it's a really important role because she provided that level of guidance to our employees. So I'm happy to have her here, and if anything does come up as sticky or in matters of interpretation, I certainly confer with Cheryl, so she understands what the commission is thinking and where they're going. So thank you.
Nice to meet you, Cheryl. Thank you. Okay, moving on to minutes approval. So you all should have in your packet the minutes from the last meeting. Any comments? If not, I need a motion to approve.
I'll make a motion to approve.
All in favor? Aye. Any opposed? Motion carries. Public comment, I don't see anybody here. So we will move on. Any new business, Scott?
No new business?
Okay. So we're on to old business. First thing is the adoption of a revised complaint flowchart, which was also in your packet.
So if I may speak this, I'm going to put it up on the screen as well. I do have a couple hard copies if anybody wants one to look. It's not the one I passed up before the meeting. It's the one that looks like this. So if you want to.
The other one too.
All right, absolutely.
Thanks. Another one before the meeting, do you have?
Yeah, that's the one that you have. Oh, no, I'm sorry. Here.
I need one of those too, I think.
There you go. When you were reviewing the operating procedures, it included an exhibit 1, which is the flow chart. And if you remember, I put up a really comprehensive flow chart. I mean, it was a bit of an eye exercise to read. Very thorough, very comprehensive, admittedly, but it was a little bit too much and the commission said, you know what, simplify that. So taking that direction, and I do appreciate that, it was a really good direction. It was really reduced down just to the basic steps, and we had a chance to review this. It took a lot of the detail out, a lot of the the stuff that happens behind the scenes. I can walk this through, or if you've had a chance to see it, or discuss it, I'm happy to do so. Or if there's any questions about what's being represented, I'm happy to respond to those questions. But I think it's simple, straightforward, and includes a color-coded legend, which the previous one did, to let you know the various steps, complaint receipt, sufficiency review, administrative hearing, and orange, and then whenever the process terminates, it's kind of in, I don't know, that's an orange, maybe red, orange, and orange. So, you want to discuss it? Any questions? Any
I
thoughts?
personally like this a lot. It was, for me, I think way easier for a layperson to actually look at and understand what the process is going to be. The other one was great for like our commission, but for the average person, I think it was like, yeah, really would have been harder to understand, so I like this one better, but anybody else have any comment?
No, I think it's useful.
Well, appreciate it. Just so we know, the other one still lives. So if you ever want to review it, I'm happy to bring it up on the screen. But it really, I think as a roadmap of the entire process, yeah, there's a good resource. But with that, I think we would just need a motion in a second to adopt that, or amend the operating procedures to adopt this chart as Exhibit 1.
So moved.
Second.
All in favor?
Aye.
Aye. Any opposed?
Sure, if you could repeat the names of the people who made the motion in second, that would be helpful.
Sure.
Thank you.
I don't remember. Motion was made by
No current.
Bill, and it was seconded by Vanessa.
Thank you.
Okay, moving on to Commissioner Training on Administrative Hearing Process.
Now, because it's not me, it's going to be Norm. But I'm going to take this up. In the past, we've gone through mock cases, and the mock cases present a scenario and really challenge you on different aspects of the ordinance about whether something would be a violation or not. And we have some great discussions and a lot of fun with that. But that's great. But it really oftentimes falls short of if there actually is a legitimate complaint that's going to go to administrative hearing, and that hearing can be held before this commission, whether it's a gift ban act or a complaint of sexual harassment. You might hear those complaints. So we want to do some training on what is that administrative hearing process, what are the various steps, what goes into it, what should you as a commission be listening for, what should you expect. Attorneys, cover your ears, please. There's going to be attorneys involved likely, so there's going to be a lot of noise and things that are happening. So really the intent was asking Norm, the state's attorney's office, to give you some guidance on if you're in an administrative hearing, what should you be listening for, what do these different steps mean as a commission, what should you be doing, and how should you be responding. It's a legal process, and it's really based off of legal administrative hearing processes. So I wanted to take an opportunity to give you some training on what to expect with that. So with no further ado, Norm, thank you so much for preparing to speak to this. I did pass out part of the comprehensive flow chart, but this is the administrative hearing. Orange is actually the steps that the hearing, the chronology of the hearing, but on either side are tools that are available, whether it's through the ordinance or the operating procedures, tools available to the commission, or tools that are available to the party, and I think Norm will probably touch upon those too, because those may come into play. So, Norm, please take it away.
Okay, first of all, the guidance that you have in doing these hearings, the guidance is found in the ethics ordinance, and it's also found in your operating procedures. If there's a conflict between these two documents, the ordinance trumps. The ordinance will take precedent over any conflict that somebody might raise or you might find in here. But first, let me back up and say you should not be afraid of an administrative hearing. It's a fact finding, and you're the finders of fact. So you're going to listen to the testimony, you're going to look at the documents, you're going to listen to the evidence and see that documentary evidence, and you're going to make a decision based upon your own best judgment. So your job, other than the chair, which does have a more strenuous job, your job as commission members is simply to listen to that evidence and let the chair or a hearing officer, if the chair decides to engage a hearing officer, do her job, and at the end of it all, then you get to vote and make a decision on it. But let's start with a couple of definitions. Administrative hearing, which is what we're talking about. It's a hearing open to the public following a commission's determination that probable cause exists, and I'll get to that in a minute, to believe that there's a violation of a gift ban or a prohibition on sexual harassment. And the reason that it only has those two things in here is because if in the sufficiency exam, you find that there's a violation of prohibited political activity, then you don't go to a hearing on that, you refer that over to the state's attorney's office for prosecution. So that isn't included, that definition of prohibited political activity is not included here in administrative hearing. So another definition is the sufficiency of complaint and probable cause exam. Means a proceeding conducted by the commission for the purpose of making a determination whether a complaint is sufficient and whether probable cause exists. So what's the definition of probable cause?
That's actually in the ordinance. I'll put a definition up on the screen. Okay. So some definitions are in the ordinance, others are in the.
Yeah, right, and this definition is in the ordinance. So probable cause means facts that would lead a reasonable person to believe that the respondent was committing or had committed the violation. Probable cause is typically like more likely than not. That's kind of the definition of probable cause, more likely than not. So with those definitions, a violation, definition of violation. Means an action or inaction which is prohibited by the McHenry County Ethics Ordinance. That's the definition of violation. So then really what we're here for today is to talk about these adjudication procedures, and they start in Article 12. And an interesting thing, and it empowers this commission, is that you have the ability and the power to waive or deviate from the operating procedures and conduct this hearing however you think is best. You can make it more informal, you can make it more of almost like a mediation to try to get parties to come to some agreement. But it's always safer, I think, to stick with the procedure just because then it's consistent, and the more you do it, which, I mean, when's the last time we've had a hearing? It's then.
Not to my knowledge.
Yeah. And I think I was telling you, Mark, that the last time I remember a complaint actually being filed, it was really politically motivated. It was a sitting judge running for re-election and an opponent. And the opponent had somebody file an ethics complaint on the eve of the election and allege fraud by this sitting judge. And it didn't go anywhere, but that was before there was the power with the chair to dismiss a complaint sua sponte because it did not provide even enough to even go forward. It was frivolous. But you know what? It made the paper the next day, and that was the whole goal, is to get something in the paper that ethics complaint filed against sitting judge. And that's how the sua sponte came in. But, so you can waive or you can deviate. And here's like, so when we get into these administrative hearings, who's at the table? Well, you'll all be at the table. I'll be at the table to advise the commission and to advise the chair. If there's a hearing officer, and that's always your call, if there's a hearing officer, it's to advise the hearing officer. But that's who's at the table. And you as chair should not be fearful of that, because you can always turn to me and say, Norm, what is the next step here? And I'll tell you the next step. But quite frankly, if we have an administrative hearing, I'm going to give you the little cheat sheet, kind of like this, that just takes you to the steps. Swear the witness in, and the oath will be there. It's like, all you're going to have to do is look at that one sheet to go step by step. So if there's a complaint filed, it gets filed with the deputy county administrator, and Scott then forwards it to the chair. The chair then looks at it to determine whether there is enough to go forward, or does it get dismissed sua sponte. And there's actually standards in here on page 11 that give the standards. Yeah, they give the standards. And nobody expects you to remember these, but when you get that complaint, you're gonna have to go, oh, what are those standards? Let me look it up. And so you look it up. But the standards are, you know, that it's gonna get dismissed sua sponte if the complaint does not set forth facts which taken as true and liberally construed are sufficient to legally state a claim under this ordinance, or if the conduct involves a person not bound by this ordinance. There's an ethics complaint filed against the highway commissioner in McHenry Township, not bound. If the complaint is deemed frivolous, that's your decision. Or if the complaint is not written, signed, verified, and filed within 1 year of the alleged violation. So those are the standards to get rid of a complaint sua sponte. If the complaint does advance, then the deputy county administrator sends out that complaint to the respondent, and the respondent has 21 days to file a written answer. Maybe isn't required to, but certainly can come to a hearing, because you're going to have a hearing even if that respondent doesn't respond, but the respondent almost always will. So they have 21 days, and then the guidance here says that within 7 days after receiving that response, the chair will then set a hearing date on it. And so then you'll have your first hearing date for that probable cause, sufficiency and probable cause hearing. Is that am I using the right name for that, Scott?
That's correct.
Okay, so you'll have that. Here's an interesting thing is if the commission says, yeah, we think there's sufficiency here in this complaint to go forward to an administrative hearing, the full hearing, it says that you can proceed immediately to that administrative hearing, but there's another section that talks about pre-hearing disclosures and requires at least 7 days for parties to just exchange witness exhibits. But I think, and Scott and I talked about this, is I believe the commission, if it's a very simple matter, then the commission can ask the parties, listen, do you want to proceed to administrative hearing right now? You've not indicated you have any witnesses, you've not indicated you have any other documents that you want to produce other than what's attached to your complaint and your answer, and you could go to hearing right then. But if one of the parties says, oh no, I want a list and I need to give a list, then I think you've got to set that hearing date and give at least 7 days for them to exchange their information. Yeah, the sufficiency and probable cause exam is really only looking at the documents that have been filed with you. That is it. There's no testimony. I mean, each party can address the commission, but it's not evidence and it's not sworn testimony. I mean, they can say, I think this is baloney, this guy hates me, this is the only reason he's doing it, or, you know, he knows I'm running for office. Doesn't mean anything. You're going to look at that complaint, and you're going to look at the response, if any, that's been filed, and you're going to make a determination whether there is enough to go forward to the administrative hearing. Then after you have this sufficiency hearing, you've got 4 things that you could do.
Excuse me, Norm, can I just interject?
Yeah.
My assumption is that at the probable cause determination, we don't evaluate or make a determination of who's telling the truth or anything like that.
Correct.
That's just at the administrative hearing level.
Right. And basically at that sufficiency exam, they don't even call it a hearing, an examination, because all you're really doing is examining the documents that have been filed. At that, you're really taking things in a light most favorable to the complainant to determine, is there enough here to go forward to an administrative hearing? So you've got, after you have that sufficiency hearing, you've got 4 things that you could do. You could issue an order that says insufficient to go forward, and it is basically dismissed. If it's a violation of the prohibited political activities section of the ethics ordinance, then that you can, now this is again assuming now that you've found sufficiency, that would get referred over to the state's attorney's office for possible prosecution. The commission would stop at that point with those things. The other thing is you could issue an order that there's a gift, that you believe that there's sufficient evidence to believe there's a gift ban violation, and you can, but you don't have to, refer that to the state's attorney's office. And if you refer it to the state's attorney's office, presumably you won't go forward at that point. But you can keep, this is another order, you can keep the gift ban and the sexual harassment, and you can say, we find there's sufficient evidence to go forward in an administrative hearing, and then that's when you would set your hearing dates, and we would go through this process. I said earlier how the chair can appoint a hearing officer, and you could appoint somebody that you know that you want to be the hearing officer, or you could ask me and say, Norm, who do you have in your office that could preside as a hearing officer? And I think Tom Cahill has been here to a meeting or two. No? Is he not?
Not in my time. I
No,
don't think.
okay. Well, Tom Cahill is.
He was at our last meeting, I thought, at least according to the minutes.
He's not as good looking as me, but.
So the person who was here in your place, okay.
Yeah, right,
okay,
yeah.
yes.
So Tom Cahill is kind of my backup here, you know, we'll tag team off on this stuff, but you could say, listen, I do want a hearing officer, I want to be able to just listen to the evidence, I want to make a decision on listening, not trying to manage. Up to you completely. And I assume probably what would happen if you asked us to appoint somebody, either I would be the hearing officer or Tom Cahill would be the hearing officer, and the other one would be the attorney for the commission.
I was gonna say, Tom, is there any potential conflict of interest of being the commission's attorney and a hearing officer? But you said the state's attorney can do both roles.
Yeah, because like, for instance, when we do electoral board hearings, it's very common that somebody from the state's attorney's office will be on the actual electoral board voting, and then, like the last time Tom Cahill was on the board to vote on whether this person should stand the ballot or not, and I was the attorney for that board and would advise them on the law of a particular allegation.
The importance of a hearing officer, if it's gonna be a pretty sticky hearing, and sometimes you get a sense, it really was for the chair, you get the ability then to have somebody run it and control the meeting, and then if there's objections, understand, weigh the objections, and you get to listen. You get to focus your time and attention on what's being presented, what's being said, as opposed to trying to manage and confer with the attorney. So it kind of gives you that, I think, that relief of not having to manage the nuance of the hearing and let you really perform the role that you're sitting here to do, and it's, make a determination on that complaint.
Yeah, some people love that hot seat. They want that hot seat. They wanna be there making those decisions, and other people are like, I'll sit back here, you make those decisions. It all depends what you're comfortable with.
I think it also depends on what,
Yeah, I mean, if you
what
have,
we're
let's,
discussing and how serious it is.
yeah, let's say that you have, I'm just thinking of an example, let's say that the complaint is our county auditor, and the county auditor has filed this ethics complaint against another elected official for gift ban violation. That's something you might want to have a hearing officer take over, because you've got these two elected officials really battling it out a little bit. So that would be a good example, I think. Take yourself out of that hot seat. So the parties can come, before you go to a hearing, they can come to some consent agreement. Presumably they could even, let's see. Oh, at any time after filing the complaint, a consent agreement between the parties can be entered. So they could be in the middle of a hearing and say, let us step outside. We want to see if we can work something out. And your operating procedures on page 14 list what has to be in that consent agreement. And as long as the parties can come to some agreement and those things are in that agreement, then you can enter it and you're done with your hearing at that point.
And the consent agreement functions similar to, basically somebody's gonna plead guilty. Rather than going through the whole administrative, hearing, if they say, all right, you got me, and, to work with the commission on, okay, what would the penalty be, whether it's a fine or, but that consent agreement, I think, really gives that opportunity for to avoid the administrative hearing process if somebody, in essence, plead guilty. Is that correct?
Yeah.
But they basically have to plead guilty in order to.
Yeah.
Because I was like, I don't know how there's an agreement, right? I mean, if somebody says you violated the Gift Ban Act, and then they want to go step out in the hallway and decide for political reasons, whatever, that, okay, it's all good. Now, it's like, wait, there's still a violation here on the table, right?
Yeah, and typically then what would happen is the respondent would come back and say, look, we've talked, we kind of have an agreement I'd like to submit to the commission for approval. And you'll see here, here like the consent, any consent agreement containing consent findings and an order disposing of the proceeding or any part thereof shall also provide an order that shall have the same force and effect as an order made after a full hearing. The entire record on which the order may be based shall consist solely of the complaint and the consent agreement. Any procedural steps before the commission are waived, or further procedural steps are waived, and any right to challenge or contest the validity of the order is waived. And then the order and the decision of the commission is final. So you have a lot of power in accepting consent, entering into a consent agreement with that respondent.
So we could say no.
You could say no, yes, you could, yeah.
But I think the scenario would be, let's say the complaint's against me. You know, and Cheryl files a complaint, she's got all the goods on me, and I thought I can get through the sufficiency of, and probable cause examination and escape free, but, it's not the case. And I know in my heart, I did it wrong, I was guilty. The agreement would basically be me as the respondent to say to the commission, okay, you got me, $500 fine or whatever we would agree on as a penalty, and I would make an agreement with the commission. That would be filed, and it would be as if you went through the whole hearing, found me guilty, and then issued that $500 fine. It was something to pay it. I weigh my ability to challenge it. It's basically, like I said, it's accepting that kind of the deal, pleading guilty, accepting my fine, whatever is agreed. Because you can say, no, you know what, it's a $10,000 fine. I say, well, I may want to take a chance with the hearing. I got a really good attorney. So that's really how that process would work. But it is truly an agreement between the respondent and the commission.
Yeah.
And
Let me give you kind of what I would think would be a good example of why you might want to say, yeah, let's come to some consent agreement. Gift ban violation. It's interesting to me that a vendor can supply me a catered meal from a restaurant or buy me a meal at a restaurant every day of the year, as long as it's not worth more than $75 every day. But if that vendor gives me a gift, let's say that vendor at Christmas time gives me a $70 ham and a $70 turkey, I now have a $70 ham, 70 adds up to $140 from this vendor. That's a violation of the gift ban. But he could have bought me that turkey on Tuesday, and then as long as it was either catered or I ate it there, or the ham on Wednesday. And it wouldn't be a violation. And I think that would be something that would be a good faith argument for somebody to say, you know what, he could have done this to me every day. He could have bought me something every day, and he gave me a ham and a turkey, and it was $140. I didn't know. And that's something, does the commission want to hammer this person, or they want to say, oh, okay, we understand, That's always kind of, I don't understand that logic that a vendor could take me to dinner every day up to 70, you know how much I wouldn't have lost any weight if I had 75 bucks a day. I'd be at Texas Roadhouse at noon.
But in the consent agreement, it would be, yes, I did this, but still it would be an agreement, or we would ask for probably that the respondent would not do this again.
Yes.
So that would be entered into the order.
And part of that may be, and go and take the ethics training within the next 30 days.
There you go.
Okay, let's see. Pre-hearing conference, the whole purpose of that is just to facilitate a completion, an orderly completion of the hearing. And that's on, this is all here, it's in your procedures on page 14, so nobody's expecting you to remember and commit this to memory. It's just stuff that when you get it, you go, okay, I gotta go look at this. Or I'll call Norman, I'll get the cheat sheet. That's really what you do.
and how that would be used, and that could save time through the hearing process. Let's say, once again, the complaint against me, rather than having to prove, was I here on this certain date and time, or did I accept this, we could stipulate on certain facts, right? So rather than, having a debate about, And we can say, you know, yeah, I was here on this date, and I did this, and I met with some, but it wasn't political, and we can only argue really where that variation of kind of the story is. So we can make it much more efficient. You can just, all kind of just agreements of, rather than having to try it on the administrative hearing, simplify it and say, you know, we stipulate these are the facts, right? We don't have to argue over these, this happened, right? This document, yeah, that's real. And then from there, then you can get really into the substance of the complaint, of what the allegation is and whether or not that's a true or correct representation of what happened.
And in this section of the procedures, there are 11 things there that say, you know, these are subject to the pre-hearing conference. You know, clarification of issues, ruling on identity and limitation of the number of witnesses. If I come in and I say, yeah, I have 10 witnesses, they're all gonna say that they saw Norm at Texas Roadhouse at noon. Well, you don't need all 10. Let's just stipulate that, let's have 2 testify and stipulate the other 8 will say the same thing. Yeah. There are continuances allowed on good cause shown, and that's up to the chair to grant that if you believe that there is good cause shown, and that's a very vague phrase, but I mean, if I come in and I say, yeah, I need a continuance because I want to, let's say it's the hearing date. I've noticed it's here for the administrative hearing today. Yeah, I was going to call a lawyer, but I didn't do it, but I want to do it now. That's not good cause shown. I show up and I say, I did retain a lawyer, but my lawyer's in the hospital and here's an email from him. That's good cause shown, I'd say. Just kind of an example. So discovery. This is also part of like that pre-hearing exchange of information. And this is the section I think that talks about the 7 days. Pre-trial, yeah, pre-hearing exchange of information. But again, I'm gonna go back to what I said earlier is that, you know, you can proceed directly to that administrative hearing if the parties agree. And they say, yeah, let's get it done, let's go. And if not, if they say, oh no, I want some discovery, then this is where your guidance is. Gives the respondent an opportunity to look at names and addresses of witnesses, look at statements of witnesses, any other persons having knowledge, any writings that any other party proposes to introduce. It allows somebody to say, listen, my witness, my material witness, the guy that's going to be my support, now lives in Phoenix, Arizona, and I cannot ask him to come back here for this. It allows the commission to say, yes, you can do a deposition of him, video deposition. And both the complainant and her lawyer and the respondent and her lawyer question that person, that witness, just as though they're sitting before the commission. The only thing that doesn't really happen is, you know, objections, which people know that when they're doing these video depositions is that sometimes they'll make an objection knowing that it's got to get ruled on later by the commission. But typically there are fewer objections because they're not going to ask questions that are just truly objectionable, and people aren't going to object to things that truly are admissible. So you've got your discovery there. We talked about the 7 days prior to hearing. Venue and hearing, the venue is here in the administration building, probably in this room right here or one of the other conference rooms. And it's interesting because the definition of administrative hearing was hearing open to the public, but really, because this is an administrative hearing that typically is going to deal with potential discipline of a county employee, the Open Meetings Act does have exemptions to having it be open, and they're found in the statute, and it's cited here even in the procedures, but there are 2 different sections that would allow you to close that hearing. Now, both parties can say, no, we don't want it closed, we want an open hearing, and then the commission would have it open. And I don't know why somebody would do that, would say I want it open, but maybe if they wanted to shine the light of day on this person who filed this frivolous complaint and they want everybody to see this, then maybe that's why they do it. Kind of turn the tails, One other interesting thing here is somebody has a right to be, a party has a right to be represented by either an attorney or some other representative, any other representative. So theoretically, I could be accused of something, or I could be filing that complaint, and I think Mark, he's really good at this, he's gonna help me, and Mark could come and he could be my other representative, doesn't have to be a lawyer. Chronological order of the administrative hearing, it is right here, but basically there's a call to hearing. There's an introduction, and I would encourage the commission to introduce themselves first and then ask the parties and their representative or counsel to introduce themselves. There are opening statements. The respondent can hold off on doing his or her opening statement until the close of the plaintiff's, the complainant's case. They can wait and then give their opening after that. But when it comes to the witnesses and evidence, the complainant goes first, would call his or her witnesses, would introduce his or her documents, and the respondent gets to cross-examine and challenge those documents. After that, the respondent can call witnesses and introduce their evidence, their documents. And then there's rebuttal testimony that's allowed. If the respondent gets up and says, I was never at Texas Roadhouse at noon, and the complainant can call somebody and say, yeah, I was sitting right next to him. He was there at noon, I was right there, I was right next to him. So there's rebuttal is just to rebut something that's been said already in the proceeding. There's nothing new allowed in the rebuttal. For instance, I can't in my rebuttal bring out something totally that hasn't been mentioned by the complainant or the respondent. It's kind of, it is confined to that area. And there's a little difference here. A lot of trials, when you are examining a witness, an adverse witness, you are confined to whatever they've testified. A very common objection is beyond the scope. In other words, I asked you about A, B, and C, and now Mark's going to ask you about D, E, and F. I could say objection beyond the scope in a normal trial. I didn't ask you about that. He'd have to call you as his own witness to get you beyond that into D, E, and F. But in these proceedings, when you are cross-examining, whether it's a witness or it's a party, you are not bound by that scope of the direct examination. You can go beyond it. It is really way more of a fact-finding mission to get more of it out there. And that's an important distinction because lawyers that have not done this administrative hearing prior are very likely to make an objection beyond the scope. And that's where you cite, no, sorry, it's objections overruled. Our rules allow us to allow testimony and questions that are beyond the scope of what's already been asked. So the closing arguments, and I'll get to evidence here in a second, but the closing arguments, the complainant goes first, the respondent goes second, and then the complainant, because they have the burden of proof, then they get their last bite of the apple and they get to go last on a closing argument. Opening statements are really intended to just be, here's what I think I'm going to prove to you. Here's what the facts of this case are that I believe. Closing arguments are, this is what was proved, this is what happened. There's a difference there. Subtle, but there's a difference. There are no motions to dismiss or motions for directed finding. So if I'm the complainant and I close my case in a normal suit, it's very common over in the courthouse. I rest my case as the plaintiff, for instance. It's very common the defendant says, Judge, I move for a directed finding. They haven't provided enough evidence to even go to the jury or for you to even need to hear one other word in order to say not guilty or finding for the defendant. Not allowed here. You have to hear the whole case. Evidence. Evidence is under oath. The oath is actually in the procedures, and I would have that ready for the chair or the hearing officer, just to be able to pull and go and just read it right there. The parties can call and examine witnesses, cross-examining witnesses, introduce documentary evidence, can impeach a witness. And for people that don't know what the impeachment is, basically impeachment is where you catch somebody saying something different now than they've either said or written before. It's a very powerful tool in court, and it should be a powerful tool here as well. Because let's say I'm the complainant. My complaint, I say that Mark was at Texas Roadhouse at noon on that Tuesday, and then come to find out, through that evidence, he really wasn't there. I can't now say, well, it was 5 o'clock on Thursday. Well, which is it? So you get impeached that you're testifying differently than what you've written down, and it really calls into credibility the testimony of whoever you're impeaching. Objections, you can, like, one of the most common objections is hearsay. And the definition of hearsay is an out-of-court statement offered for proof of the matter thereof. And you can allow hearsay that would explain or clarify some other testimony, some document. You can allow that. There can be an objection to hearsay at any time. And, a lot of judges when it comes to hearsay, unless it's just this is clearly hearsay, they'll say, listen, I'm going to let it in for whatever it's worth. I'm going to let it in for whatever it's worth. And then you determine what it's worth. Whether you think me saying, well, Joe told me he was there at noon on Tuesday, is that, you're going to let that in, or like, we'll take it for whatever it's worth. The findings and your decisions, your findings, your deliberations they can be in closed session. You can deliberate in closed session. You're going to render a decision within 30 days of the conclusion of that hearing, and that's in writing. And here's where I would say you're going to be your challenges. That's how I've marked this down. If you have argumentative parties, and they want to argue with each other, I will tell you that the best thing the chair can do is the old Barney Fife, nip it in the bud. The first time it happens, you admonish them, listen, you're here to address us, not each other. You address us. And if they still want to argue, you say to them, listen, this isn't going to benefit either one of you. So you address us. And if you have to recess the meeting, I'm going to recess this until this calms down. So if you guys want to waste your time, we can waste some time here, but we're going to recess until you two calm down. You could have confrontational attorneys. Same thing. You admonish them right out of the gate that you're not going to put up with it, that this isn't going to be a kangaroo court. If you have somebody that's making constant objections that are just in order to throw the other party off, to throw their timing off, and they are frivolous objections, before they even finish the objection, you say overruled, 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 overruled. And they'll get to the point where they realize that, I'm not doing myself any good here, I'm looking foolish. And the same with interruptions. If, some witness is testifying and I've had clients that would do this where they're sitting here next to me and it's like, he's lying. You going to let him lie like that? It's like, that doesn't do anybody any good. You just admonish them. You say, listen, we can't hear them if you're talking. So when you'll have your turn to talk, Mr. Smith, you will. We'll listen to every word you say. But right now we have to listen to Mr. Jones. Those are the challenges I think you have, and those are more behavioral. And I think you just got to stop those right out of the gate, because if not, it'll get out of control so fast. So burdens of proof. Probable cause. And that's in probable, I already read that definition of probable cause. Clear and convincing evidence. And that's one of the standards of your findings, clear and convincing. There's no definition of that, at least not in the procedures. I don't think there's a definition of that. There isn't in the ordinance either. But clear and convincing is really, It's proof beyond a reasonable doubt.
Like a timestamp on a video.
What-
Like a timestamp on a
Oh,
video.
yeah, well, yeah, but you know, clear and convincing evidence is your standard to find somebody guilty, to find that they violated this statute. So it means proof beyond a reasonable doubt. And a reasonable doubt is what is a reasonable doubt? You know, the sun rose in the west yesterday. Well, I don't think anybody could say there's, you know, reasonable, there's nobody could say, yes, the sun rose in the west. But if somebody said, I couldn't see the sun come up in the east yesterday, well, maybe there's some reasonable doubt there. You know, why couldn't you? Was it cloudy? Was it foggy? Well, you know, I don't know, I'm struggling for a good example for you. But that clear and convincing or beyond a reasonable doubt is just something you have to wrestle with yourself. Do you have a reasonable doubt that some key factor in this case was not proven? And if you think it wasn't, then you would vote against the violation. And so finally, we get to the penalties, and I thank Mark for this because he was the one that asked about this. And the penalties that you can assess are found in the ordinance on pages 13 and 14. And it's penalties. And so it has the penalty for the state's attorney who prosecutes the prohibited political activities. Then it has your penalties that you can assess for gift bans, for sexual harassment, and they're all right there. And so when it comes down to, let's say you find that yes, there was a violation of the ethics ordinance, what are possible penalties? You go right to here and this will tell you what your ranges are. Gift ban is somewhere between $1,001 and $5,000 if prosecuted by the state's attorney. Gift ban for you guys, they could be fined in an amount not to exceed $5,000 per offense. So you just have to come to this and look, okay, what are our potential penalties? And then finally, there is a penalty for filing a frivolous complaint, a false complaint. And that's found in here too. And that's what I've got for you. Yes?
I've got a few questions.
Okay.
The written decision, who writes that, or how does that happen?
Well, I'll tell you, typically, you know, if you ask the lawyer to write it, we'd write it. Because that's when we do the electoral board hearings, the lawyer writes the decision for the electoral board.
That's not something I would have to, I would say, okay,
No,
this is our
you would
decision,
say,
you guys would
you
write
guys
it.
would have your findings, you know, the lawyer would listen to your findings, would listen to what your rationale is and your penalties, and then the lawyer would write it up. And quite frankly, if I'm the lawyer that's sitting there, I'm taking notes, I'm taking witness call documents, and taking all that so that I can put into that written finding, you know, kind of a chronological exhibits that were entered, witnesses that were called. I don't have to do verbatim, because there will be a record of it. I think we always have a court reporter, don't we, Scott?
We've not had administrative hearings, so. But
Oh, okay, well, we will, I mean, we will. So there'll be a record, so there are times I'll just say, you know, the following, or I'll say, including what is on the record, the board made the following findings. And so I won't maybe not list everything, but list the crucial things.
And on that, you have 30 days after the close of the hearing to render a decision. So once they finish the closing arguments, you don't have to then deliberate and say, okay, where do we go? You can actually take some time to reassess it and then reconvene. And within that 30-day period, though, that's your magic word. So if you want to say in a week or 2 weeks, come in. And at that time, that will give opportunity to, you know, I think with the attorney, would kind of get an understanding where things are going or present, you know, some of the findings that can help develop that written finding with the discussion of the commission after that. So it's not immediately following, like you render a decision and bang the gavel. So you get a chance to really digest what you've heard and come back, and then you can meet as a group and say, okay, what do we think? And from there, develop that decision.
Is there a possibility that we can't decide? And I'm just thinking, like, what if one of us has to recuse themselves because of some conflict from whatever, now we're down to 4, or what if we just can't get one of the members to make a decision? I mean, what happens?
Yeah. Well, as far as recusal goes, there is a whole process here for that. Like a board member themselves can say, listen, I think I have a conflict here, I want to recuse myself. Or a party can come in and say, you know what? I want Mark to recuse himself because he lived 2 doors down from me and he used to complain about my leaves blowing in his yard. So I want him to recuse himself. And he doesn't have to, but then the board would discuss it, the commission would discuss it, and then the commission would vote on whether to kick Mark off, and Mark doesn't get a vote for that, but he can certainly discuss it. I never complained about his leaves. I just said, wow, his trees have a lot of leaves. But it'd be the commission that would either kick him off or not. Now, as far as that voting goes, that's an interesting question, because I didn't really look at that, like, does it have to be unanimous? Probably not.
No, but in the case of, it'd be, say, split 2-2. Let's say guilty and not guilty.
Yeah. Scott, do you know if there's a provision here for what the voting would be on that?
I do not recall it, and I'm looking through, that's.
I'll look through it again too. We'll look through it, we'll get an answer for you, because I don't remember if it's just a majority.
So it does say early on, an affirmative action of the commission must be 3. So you need to have at least 3 for an affirmative action of the commission. So if it's 4 members, obviously you would need 3 out of the 4. If it's 5, you would need 3. And that's important to note because back before I was in this chair, when I was in your chair, we had a sufficiency probable cause examination, and there were only 3 members in attendance. So we were able to hold the meeting, it was 3 out of 5, but 2 voted one way, 1 voted the other, which means it wasn't upheld. Because you need
to be unanimous with 3.
Yeah, even though 3 said, yep, sufficient and probable cause, because the 3rd one didn't agree, it didn't go forward. So we're going to review that, but I'm going to speculate there.
No, I think you're sure right.
It's going to require there's at least 3.
Now, is that in the ordinance or in our operating procedures?
That's in the, that's a great question. It's in there. The question is where is, I believe it's in the ordinance, which means it would be compelling.
Which means we.
But while we discuss, I will go through under Ethics Commission.
Yeah, it's funny because I just saw that too, where it talked about the quorums and you have to have 3 people voting, at least 3 vote. It has to be unanimous. 3 people have to vote in the affirmative or negative.
Is proxy voting possible?
No, proxy voting is not. No, it has to be in person.
And so if we were having this meeting today, which since there's not a hearing or sufficiency examination, and let's say Dawn couldn't make it, but she wanted to participate remotely, you would have the ability to participate in this meeting, let's call it a business meeting, remotely. But if it were a hearing, you couldn't. You have to be in person.
So I just want to come back to Shelley's question for a second. So if we can't get 3 to agree, then is the complaint automatically dismissed?
Yeah, it would be dismissed,
wow.
yeah.
So
yeah, it kind of like, yes, it kind of be like either the complaint is sustained and you're going to give penalties, or it is dismissed because the burden of proof was not met.
So in the ordinance, under the Ethics Commission provision, section 3, which I have up on the screen, might be small to read, it says a quorum shall consist of 3 commissioners, and official action by the commission shall require the affirmative vote of 3 members. So that's in the ordinance, but I think it's something that maybe I can work on, and perhaps there's some clarification and a future revision to the ordinance could be recommended.
Well, honestly, I think, you know what, I think that is, Scott, I think it is pretty clear that it's just affirmative action, and affirmative action would be either dismiss or to uphold the complaint.
And then my last question was, at any point in the administrative hearing, can anyone on the commission ask any questions? Or are we literally just listening and not allowed to ask anything?
I don't remember seeing anything in here about that. I do know, I'll take a look at the administrative hearing statute that we're supposed to follow in this to see, but I don't remember anything in here. I will tell you that judges certainly ask questions, and There are some lawyers that hate it when judges ask questions, because let's say Mark and I are going up against each other, and Mark he doesn't ask some critical things. And he didn't ask, where did it happen? Well, he didn't ask what time. He didn't ask who else was there. Do I want a judge then saying, oh, to that witness, well, what time was that and who else was there? He fills in all the blanks, and I've had that happen to me in a case where a judge filled in the other person's blanks. That's not the judge's role. But I've had judges, what a judge's role is saying, I'm sorry, did you say it was Tuesday or was it Thursday? I didn't hear you. Or say, just a moment ago, you said Tuesday, but now you said Thursday. Did I hear you right? That I think would be completely appropriate, because you're supposed to make your decision based on the evidence that's presented. And if in your mind it's like, hey, this person's lying Tuesday to Thursday, that's one thing. If it's like they just got their days mixed up. There used to be a judge on the bench, Judge Sullivan, who was on the bench a long, long time. And you would have thought during a trial that Judge Sullivan was asleep half the time. But he was not, because, he never was, but you would think it, because he would just be sitting there like this. But I remember in a trial one time, and the witness said something about it was June 17th, and the judge, without skipping a beat, said, you mean June 18th? And the guy goes, oh yeah, June 18th. So he was listening to everything that was being said, but that's like a good example. The commission can certainly ask things like that.
Well, I'm just thinking in a hearing like this, they may or may not be represented by legal counsel, and so expecting them to ask the right questions or present the right information that we might need to know is kind of a high bar, and that maybe we might have some big open questions to make a decision.
Well, that's possible, but it is their burden. It's their burden of proof. It's not you to get their burden of proof out there. That's where I would caution you with these people that are representing themselves. Because then what happens if you get accused that, boy, you helped Mark out a lot, but you left Norm hanging. You filled in all his gaps, and you didn't even ask me about, filling in my gaps. So you have to be a little careful with that.
And I feel like it's kind of tough, because I think we were talking about a normal, legal proceeding, when you've got two parties that have a complaint against each other. In this case, we're talking about a complaint that is a violation of, like, we're trying to protect the taxpayers and
Right.
and this government, and so we're not really, I guess maybe I'm viewing it differently, but it's like we're not trying to protect one person or the
Right.
other. We have a different role in this commission. So I would think if they didn't present, the complainant didn't present all of the information that we might need, we might still feel there's a legitimate complaint here, like they just aren't good at presenting their information or whatever the case may be. But if we still feel there was maybe a serious violation of the Gift Ban Act or something like that, I don't know, I can just envision where there might be some questions where we feel like we have to do our job, to.
Do we have investigative powers?
You can, the commission does, the chair has the power to appoint an investigator to go and get things like documents or interview witnesses, get statements, things like that.
So besides being able to call witnesses, we can call an investigator to check on this fact or that fact?
Yeah, you can do that. And I think that's gonna be the rare circumstance.
But it's possible.
Yeah, and Shelley, going back to your point, it's just, judges hate, and you're in judges' positions here when you're making this decision. Judges dislike having what's called pro se or self-represented people in front of them, because judges are torn. And when I would have a self-represented opponent, I would walk very gently, because two reasons. I did not want the judge to think that I was beating up on this person because I'm a lawyer and they're not. And then the judge would hold that against me possibly, or my client. But the other reason that I would go gently is I didn't want that person to walk out of court and go, well, I got screwed by the system. I got screwed by that judge and that lawyer. I wanted them to feel like they had their day in court. So I wouldn't object. They could say stuff that was maybe clearly hearsay, maybe clearly irrelevant, but I wouldn't object. I'd get your day in court. You know that you were heard, and if you lost, you lost. And that was my philosophy, but other attorneys would be totally different, and judges just, they would just see people get raked over the coal, and was justice really served? Probably not. But at least in that courthouse, pro se people that represent themselves are supposed to be held to the same standard as lawyers before the bench. So I don't know, you can even put in your decision, if you don't think if they haven't met their burden of proof, you can even say in there that the complaint unfortunately did not meet their burden of proof. The commission felt that there was something here, but the complaint did not provide the necessary facts that we would have needed to find a violation.
Yeah, and I think that's where you can ask questions too, as fact finders. If you're getting information here, but you're not clear on something in the middle, as fact finders, you can ask that, and if you can get that response to clear it up, I think it would be fine. But maybe there isn't a good response, which means that information is missing or it doesn't exist, and that may help make your determination. So you could ask those questions to clarify, or if something appears to be missing, you're trying to find those facts, and I think that's pretty rolling.
Yeah, but then we become an advocate, won't we?
Yeah, that's what you have to be careful. You have to be careful making it where you are trying to fill in those gaps for somebody as opposed to just trying to clarify something. That's where you it gets dicey.
That's a good point.
Yeah.
I'm getting a little bit confused though, maybe, because, I'm envisioning if there ever is I get that, like, two elected officials fighting against each other and want to do whatever, okay, that's a different case. But I'm envisioning the case where, regular employee just doing their job, doesn't have an axe to grind with anybody, but happens to be in a position where they observed a serious violation of the Gift Ban Act. And they're just trying to do the right thing, right, and report it the way that it's supposed to get reported. And now we expect that person to come before this commission and present all of this evidence and do all of this, and they're just like trying to do the right thing. They don't have an axe to grind with this person. They're not so I kind of struggle, like, what do we do as a commission with something like that, which to me is completely different than a complaint where two people are running for office and someone's trying to get somebody on something, right?
Yeah, it's a difficult line to walk, but in England, for instance, it is truly a fact finding. Courts are truly a fact finding, and judges take a much more active role in what are the true facts here. But our system here is that you present your case, and really we're not out to find facts. We provide you a legal system in which to present your case, and then we decide based on what you presented.
But I thought we are out to find facts. I thought we are
but you're finding them through the testimony and the documents that come through here. I would, if I were in your chair, I'd swallow hard and I would just base my decision on what was presented to the commission. That's what I would do. It's just you've got that obligation to bring it forward.
That sounds fair.
Yeah, it's the safest thing for the commission to do, because that way nobody can claim that you either took a side or, because there's an appeal process. If whatever the commission makes, you go over to the circuit court and file a complaint for judicial review. And the judicial review is looking at the record, the transcript, and looking at the documents that were presented. And if that judge starts reading in there that, yeah, boy, the commission really took an active role on behalf of this complaint or on behalf of this poor respondent, then the judge could overturn that and say it wasn't a fair hearing.
Sure.
When do we have the authority to refer a matter to the state's attorney at any stage of the proceedings?
You could, except if you have like the prohibited political activities, as soon as you say, hey, there's sufficiency here in that exam, then you refer that directly to the state's attorney at that point.
But I'm talking about at other parts where we think
It talks of the gift ban, yes, but it does not talk about sexual harassment being referred to us. But the gift ban, you can refer to us, but not sexual harassment.
So if they start in the course of an administrative hearing for a gift ban act and decide, wait a minute, there's too much here, could they then stop the administrative hearing and then turn it over and like midstream? to
There's some
the-
specific language here. Let's see, hang on just a second.
Like if you find that there is maybe more violations than just this one, or this violation's much bigger than it initially appeared, because that would be, in my mind, a reason to refer it, because you'd want the penalty to be higher than what we're allowed to give, right? If you find that the violation's not what it was initially shown to be.
Well, your penalty is the same as theirs, up to 5,000 for a gift ban.
Oh, I thought when you read them earlier that there was higher.
State's attorney's a minimum of 1,001 to 5,000. You can go up to 5,000.
Okay.
So yeah, but the thing to keep in mind is, as the Ethics Commission, you're not making complaints. So if there's other things that come out and you say, well, geez, that was a violation, it's not your job or even your charge to bring that forward and file the complaint. Somebody actually has to file that. All you can do is respond to complaints that were filed. So if other things fall out of the woodwork during this, that's not something that you can act on. You can only
Right,
act on
I'm
the
just
complaint
thinking
that's
that the
filed.
complaint is not what it initially was represented to be, so.
Well, and here's your language. It talks about gift ban, for instance. Let's say you find the complaint sufficient. Says that you can issue an order finding the complaint is sufficient to allege a violation of the gift ban and that probable cause exists, and refer the matter to the McHenry County State's Attorney. Or issue an order finding the complaint is sufficient to allege a violation of the gift ban and the prohibited sexual harassment, and then proceed to a hearing. So you have the option, but I'm not so sure once you've commenced a hearing for gift ban that you can stop it then and then send it over to the state's attorney's office. Now maybe, and I think it's probably written that way, so if the commission really believes that, boy, this is really an egregious violation of the gift ban, this isn't a $70 turkey and ham. We're talking about this guy got a brand new boat from the marina to give them the business from the sheriff's office for the Marine unit. That's something you'd probably say, we're not gonna, this is way bigger than we should be dealing with, we'll refer that over. Okay?
Well, I think that makes sense too. If I were, say, the respondent in a hearing and I've got my attorney and spent all this time preparing for the case, and you start the administrative hearing and then they'll just say time out, I want to give it over to the state's attorney. Now I have all that cost invested in my legal defense and my attorney fees. Is it fair that I'm out? So, but I think that's something maybe perhaps we should clarify. Norm, we can confer on whether or not it should say if the commission starts on the hearing process, it should see it through.
So I'm understanding what the commission is supposed to be doing. It just boggles my mind, because I think to myself, why, unless you do have an axe to grind with whoever this other person is, why would anybody ever bring a complaint here? You know what I mean? Like, if I'm just an innocent employee and I see this stuff going on, it's like, there's no incentive for them to bring a complaint when they have to hire their own attorney. What do they care? They're trying to protect the county. Like, they're not gonna go hire an attorney.
So, and I wanted to touch on that. And when the ethics ordinance was rewritten a few years back, that was one of the concerns, to make this process a little bit less daunting for a complainant to bring forward. We want them to, if something bad is happening, we want to encourage that complaint to be brought forward. And it could, an employee may not be well equipped to bring it forward. They see it, they know it, here's all the documents, they've got pictures, but they're not one to carry it through. So in the operating procedures under filing complaint 12.04, and I'm gonna make this a little bit bigger, on the screen, we talked about the commission chairperson may appoint an investigator / prosecutor. So when the intent would be that somebody can bring it forward and say, this is happening, here's all my stuff, but I'm not gonna hire my attorney, or I can't, testify. Or they may have to testify, but this gives the chairman then basically to hire that investigator to develop the case and then bring that case forward, to prosecute that case before you. So it wouldn't be the complainant. Now, they probably would have to be sitting there since they were the complainant, but there would be a resource to kind of do the professional work, and bring that case forward as a prosecutor. So that's how I read that. And that the intent is so somebody wouldn't be dismayed from, raising a red flag of something.
So this commission could decide between a case where two people are just trying to get at each other for whatever reason, and a legitimate case, and be able to, well, so essentially, I mean, we are helping that person. I mean, when we.
You have a tool, very much a tool to help that person, help a complainant, and really to bring justice. And employees just doing their duty, and see if it's wrong, and they want to bring it forward.
That makes more sense to me, because otherwise I'm like, I don't know why as an employee you would ever.
Scott, can you find 264070B1N? Because at least on a copy of the ordinance I have, it doesn't exist. They said pursuant to that section.
What section were you talking about? B1N?
That's what it said, yeah.
Yeah, it's on page 13 of the ordinance. It is on page 13 of the ordinance. It's at the top of.
264, is it B?
No, well, it says pursuant, said you may, the section that you had, you were just reading, say you may appoint an investigator pursuant to section 2.64.070B1.
Yeah, it keep going down, Scott. Right there, hold on, right there. You go up, there's N right there. To determine that there is, and there's where it talks about appointing a licensed attorney to investigate and prosecute. And like in Norm.
Okay, well, I got my copy from whatever
B1.
that's the current ordinance.
This is one.
I went to, where we find the sections of the ordinance for the county. It's admin, I forgot the website.
Oh, I just go into the search bar when I look them up, but that's
Okay.
all. But I've got, this is the set that I have, I think it's the latest set.
So that might be a reference that needs to be cleaned
Or
up.
I've got, I don't know where I got this, but, I mean, I know where I got this, I just printed it off.
You don't have a section N there?
No.
We have a section N, but it's B, I'm sure it was one.
B1N.
B1N.
Yep.
B1.
It's down.
Yeah.
Next page out of that, right there's the N. What is the date?
Oh, right here, the commission may contract with a
Yeah.
licensed attorney to practice on the state of Illinois, investigate and prosecute. Yeah,
For
it
the
was in
commission.
Yes,
Yeah.
that's in there. I thought that was in there, because I thought it was a cleanup that we had to do. So,
You may have an older version
I
there.
must have.
Yeah, yeah, you might.
Good catch, Leslie.
But that's concerning if you got that from the county's website.
Well, this is on the county's website, that's where I pulled it from, so if you go to the,
No, not yours, Scott, I meant
Mine.
Bill's.
You have to go.
If he received his from the county's website.
right, but that's the version I just put on the screen was from the county's website too.
Oh.
So if you go to county government, it's under meet your county board members, ethics commission. And so this is where all that information lives, your
I
information,
went to ordinance on the county
There, yeah.
website.
Oh.
Right there,
ethics ordinance,
yeah.
okay?
No, see, I didn't get it right from the website, I got it from where the public can go get another
Oh,
source.
so the codification,
Right.
then we need to make that change because that is the wrong version, okay?
I'll let you know where I got it.
Yeah,
I remember.
I suspect you got it, and we'll confirm that if you go to the county's website,
Yep,
Code of Ordinances.
that's where I got it.
So this is a third party that,
Right,
yeah.
I know that, yes.
Yep, yep.
That's where I got it. I got it from, that's the link.
Okay. All right, well, we'll make that clarification. We'll make sure codifiers have obviously the most up-to-date ordinance.
And I'll throw this away.
Okay.
That's all I have.
I want to touch
What
on.
about other, I'm sorry, go ahead.
I just was touch on two things. We have a section in the operating policies really talk about ex parte communications. And really, when you get into that complaint that's filed, if you got contacted from the respondent, the complainant, or their attorneys, you're really not allowed to talk to them. Right? If you're going to talk to them, they both would have to be in a room. So keep that in mind, because they may want to call you up and say, hey, Vanessa, let me tell the floor, but I might make sure you listen for, can't do that, right? It's got to be a fair playing field. And then right actually before that section under evidence, there is a discussion where if somebody's going to present a case, and let's say I'm bringing on the case, and I have a stack of time cards this thick, and I say, you know what, we're going to go through each time card, and we'll show you where Norm was or wasn't there when he was at Texas Roadhouse. And we spent you actually have the ability, because it's, to kind of stop, you can stop that, that evidence. So just because they want to present it doesn't mean you have to listen to it. That is in section, ex parte, I just had it up. Oh wait, it's in the...
It's about, it dealt with our ability to rule on the evidence. It said if it's time consuming.
That's, yeah, that's right. So, appreciate that.
Is that the same example about, like you said there were 10 witnesses, but
Yes.
we only heard from 2?
Yeah,
And should be, that's enough, sufficient.
yeah.
Yeah. But anyway, so I could find out language, but that's, that point is there, just so you know that you have tools, and really the intent is to make it an efficient process, that you're not going to be wasting days and days and days going through, tedious documents. And I think that the attorneys might have, or whoever will tell you why it's important, and then you have to make a determination, but you're going to have to weigh that.
I think if you just scroll back down.
Yeah, that's right.
I just passed it, right?
Yeah, all relevant evidence right there.
Okay.
Exclude evidence.
No, that's not, yeah, right there.
Yeah, right there.
G.
Discretion exclusive is probative value is substantially outweighed by the probability that submission will necessitate undue consumption of time. Leave the attorneys to determine what that means, but that's what I understand it to be. So,
Yeah.
I'll tell you, I was prior to here, I was in a matter, and it had to deal with timesheet records, and I mean there was boxes and boxes and boxes of documents, and really it was tedious. It was going through all that, and really the question was, what is this going to show? What is this going to prove? And so I've seen that in action. That's just so you know. I'm glad you have that tool available to you. So really, that's the administrative hearing process. Hopefully, you never have to use it.
We want to.
Exactly. After all of this training, it's like, not that I want anything to happen, but it would be nice to, use our training at some point.
So right before this meeting, I was meeting with their EMA director and emergency management. That's something too. Always prepare, always prepare, always hopefully they never have to be called into action, because I mean something bad happens. So I appreciate that you want to use it.
Yeah.
I feel kind of bad for you because you do all this training for us, and like in February, I mean, my term's up. And I think your term's up, maybe.
I think mine,
Oh,
Dawn's
yours
is
as
too.
well.
I think 3 of us
So
are
then you
up,
have
yeah.
to train all over again.
But you'll have the option to reapply. I certainly would consider that because you are well trained. It actually used to be a 2-year term. Now it's a 3-year term. For that very reason, you lose continuity. Because you've seen, now you know what goes into it. It's not an easy job that you have. I know that specifically for sitting in that chair. That's a concern because the county needs people who know this ordinance and can really be the arbiters in case a complaint comes forward, and to be fair and impartial, but understand how that process is going to work. It's really not simple. I can pull up a complex flow chart and show you it's not simple. So I appreciate that. But the important thing is that you're sitting there and you're getting trained and you know it. And whomever's there will keep training and keep training on it. So when that time comes, the county will have a commission that is well prepared to do your duty. Any questions for Norm?
Are there any other ethical considerations besides the main 3 that seem to be listed here? Like misrepresenting the county, like you were using the example of a marina. Let's say that a county board member misrepresents the needs of the county. to the marina?
No, because this statute, the ethics ordinance, strictly limited to those three things.
Okay.
Gift ban, prohibited political activity, and sexual harassment. And that's why if you have if a complaint comes in, this is exactly what you're saying, that, oh, we think that the sheriff's department is misusing money with their marine unit, that's a sua sponte dismissal. It's not part of our statute. Now, part of that is, yeah, he got a gift in order to have Captain Joe's Marina house his boats. He got a kickback. Well, that is.
Well, who handles that type of thing?
But that complaint didn't come,
Is that
but this,
illegal?
Yeah, that would usually come through some criminal complaint, that if there was some bribery, some graft that was taking place in order to a tit for tat for services, and I'll give you this, you hire my company, which that's probably more common than anything you see in here, especially in Chicago where you're looking at, I mean, it's just like,
Daily.
it works on trial right now for basically that. I'll get you your zoning, you use my law firm.
Yeah, the ordinance is really clear. The powers and duties of the commission are limited to matters clearly within the purview of this ordinance, and addresses those three.
Just those three?
Yep, so questions of like moral turpitude. Somebody may not be a nice person, and that may be a matter for another venue, but not for this. You're limited to those three. There was a version of the ethics ordinance that the county was considering that did expand those areas. It included nepotism, included conflicts of interest, in a few other areas which was going through, but ultimately when the county board voted on, they pulled that back and just limited it to these three. Sexual harassment was a change because the statute changed to include it, which means this ordinance had to change, and that was the impetus to really think, okay, what else could we do? But all those other areas, they were taken off the table and just limited to these three.
Yeah, and I think historically the reason those were pulled off is at the time there was this suspicion that those areas would definitely get used in a political fashion.
Yeah, the revisions to the ordinance, like I said, they included a lot more tools really for this process of sua sponte. We talked about the hiring an investigator to encourage, if something's happening, we want people to be comfortable bringing forward a complaint. But we saw a lot of weaponization of this, and this revision really addressed some of this. That's not to say that as you go through it, you won't see or hear or you know what, you'll come to think that there could be other areas that maybe need to be tweaked. It's always a work in progress. The ordinance requires county board to change it. It's their ordinance. Their operating procedures, they're yours, so you can change those, just like you did today by adding that exhibit. But even as we go through, like this administrative hearing process is outlined in your operating procedures, not the ordinance. So anything that's process related, that's yours. If you want to add in, like maybe we have put a note, a clarification on the commission's role in asking questions, and maybe we add a provision about what does that look like, what does it, you can add that in. That's your operating procedures. It's not into the ordinance.
And nothing prohibits us from referring any matter to the state's attorney that may be beyond our jurisdiction.
Well, you would just dismiss it. You would just dismiss it.
No, Norm, I'm just saying, if something comes up that smells and it's not within our jurisdiction, one of us or the chair could always go to the state's attorney's office and say, here's what we just heard, you may want to look into it.
Yeah, I'll tell you what, if that exact thing happened, here's what I would say is, we don't investigate, we prosecute. And the local law enforcement or the sheriff does the investigation. So somebody has to go complain to the sheriff. Yeah, or to Woodstock Police. Because we get calls all the time from somebody that wants to know, this crime, my neighbor's committing this crime, do this, and I have this, I say, we're not an investigatory body, we're a prosecutorial body. So if you think a crime has been committed, I urge you so strongly, go report it, go file a police report on it. And they'll investigate it, and if they think there's a crime committed, they'll bring it to us with the investigation done.
All right.
Okay.
Norm, thank you.
My pleasure.
Thanks, Norm.
Thank you.
Yeah, my pleasure.
All right, so I assume we have no reports. I don't see any. Any member comments, any future topics, anything on anyone's mind? executive session is, I don't believe necessary, so I think we need a motion to adjourn unless there's anything else.
Motion.
From Vanessa?
Motion from Vanessa,
Second.
second from William. All in favor?
Aye.